Hi, my name is Cynthia, and welcome to Understanding and Managing Diversity. Today, the discussion will entail two words: technology and technological, and how these words apply to three situations. I have a fourth situation that I'm going to discuss, but it has nothing to do with those words. The fourth situation will involve stereotyping. So, the first thing I want to talk about is what is technology? How do they describe technology? Well, technology is described as it is the right thing to do, the greatest good for the greatest number. It's faith. Technological, that approach is hope. The decisions are based on right or good if they produce a positive result or a desired result, and bad if it produces an undesirable result. So the first situation I would like to talk about is the case law. And in this case law, it involves a university and a female employee. So the university is based out of Nevada. So let me just give you a little overview. This is a case involving two qualified candidates for the same position at the University of Nevada. Both candidates were black, one female and one male. And according to the university, each one's qualifications complemented each other. The university attests they chose the more qualified candidate at the time of hire. They hired the male, and the female was hired a year later. So let me give you some facts about this case. In 1989 to 1991, 1% of the university's faculty were blacks. 87 to 89% of the university's faculty were white. 25% of the faculty were women. The university wanted to rectify the racial imbalance, so they decided to institute the minority bonus policy. The additional faculty members was to employ a minority candidate. So the announcement went out for an open position in the sociology department with a stipulated salary of $28,000 to $34,000, depending upon the person's experience and qualifications. The department was instructed to interview more than one candidate, with the option to waiver. Farmer, the female, was one who applied and a finalist selected by the search committee. Makoba was a male, and he applied and received the offer of $35,000 per the university. So here's the argument. Makoba's qualifications, according to the university, placed him at the top of the list. He had strong academic achievements. The financial offer they increased to him was to ward off his competition. And there was a shortage of black PhD instructors. Farmer's argument was she was more qualified and hired one year later. She was hired as an assistant professor. So Farmer filed a suit against the university, alleging she was discriminated against. She alleged that she was a more qualified candidate. She was passed over because she was a woman. The university claimed that was not the case, as they had just hired and paid highly a female chemistry teacher. They said they paid her top dollar. Farmer filed a lawsuit. She filed the lawsuit alleging equal pay, She filed a lawsuit alleging equal pay, the Equal Pay Act, the EPA, by paying her unequal wages for equal work relative to a male employee of similar qualifications. She alleged that race and gender violations under the Title VII of the Civil Rights Act. She alleged that they had breach of employment, that the university breached its employment, so she used the Breach of Employment Act. She said that the university breached its employment contract with her by failing to abide by promulgated policies delineating the terms and conditions of employment. Then she alleged a breach of implied covenant of good faith and fair dealing. So, of course, the case went out to the jury. The jury returned with the verdict in Farmer's favor for her cause of action, awarding her $40,000 in damage. So Farmer won Breach of Employment Act, alleged that the university breached its employment contract with her by failing to abide by promulgated policies delineating the terms and conditions of employment. She won on the Equal Pay Act by paying her unequal wages for equal work relative to a male employee of similar qualifications. She won on alleged breach of implied covenant of good faith and fair dealing. She did not win on the alleged race and gender violations because she did not prove they hired a male. She could not prove they hired a male over her. The university timely filed a motion for judgment notwithstanding the verdict, or in the alternative for a new trial under the district court, which denied the motion, prompting the university to appeal. Teleologically, the court jury decision was a teleological decision to award $40,000 on the merit of all the claims that she alleged, except for the Civil Rights Title VII Act. The equal pay for equal work. If the Civil Rights Act Title VII could have been proven, Farmer may have been granted a much larger settlement. But the case of gender inequality was not proven. Technological theory is a theory of morality that derives duty or moral obligation from what is good or desirable as an end to be achieved. The university has a right to employ whomever they feel is right for the job. Although diversity within the campus is little to none, according to Harvey and Allard, page 2014, page 267, Understanding and Managing Diversity, stated the numbers. There are more men employed than women, and women are considered a minority. Teleological theories state theories in a particular context would be theories that apply to differences among people, and also consider the ends or outcomes in order to judge the ethical nature of a decision. So, there you have it. That argument was proven, teleological. Okay, let's use those two words again to apply them to this next situation, which is the Watchmark Company. This was a corporation of software which later purchased another company called Comnitel and became the Watchmark Comnitel Corporation. They did a lot of outsourcing. Outsourcing is when they Outsourcing is when large corporations use foreign countries to to sell their products, or it's basically contract and work abroad. Most times when companies do that, they do that because they can save money. They don't have to put up with the federal regulations and guidelines in America. Um, Other countries don't have the same policies and procedures as we do in America. So it's cheap labor for them to outsource. So, anyway, the Watchmark Communitel Corporation um, made an ethical decision to purchase another company, which was called Valiant. Later, both companies was purchased by the International Business Machines (IBM) in February of 2007. When IBM purchased Valiant, they not only purchased Valiant, but they got the Watchmark Communitel Corporation. Valiant Company had 200 clients. This was an action-based cost-benefit analysis. This was a benefit analysis of a technological theory. Technological differ on the nature the action should promote. IBM had quadrupled in size and assumed the management of all or part of their clients, applicants, and their portfolios. IBM was strategic in outsourcing, especially after inquiring Valiant for the purposes of good, the means to an end. And that is what technological does in business. The third thing I want to talk about is I want to present an argument that it's easier for employers to comply with the diversity legislation in Canada than it is in the United States. So the reason for employers it's easier for the employees in Canada to comply with diversity because it's easier for them to discriminate. In Canada, the Human Rights Act has much room for revision. Canada's Human Rights Act currently states that it forbids discrimination by federally regulated employers on the basis of race, gender, sexual identity, sexual orientation, disability, and other grounds. Well, what is the other grounds? In the United States, discrimination is not tolerated once it's found. There are sanctions against discrimination for all employers. In Canada, the law changes from provinces and territories. The Canadian Human Rights Act is conflicting. In the United States, it would be discriminating to put up a sign in a store window or in a newspaper stating only handicapped persons may apply. That's discrimination. But that is what is allowed in Canada. Canada can place a sign for blind only, for the hearing impaired only, and it depends on what jurisdiction the person resides. Canada say they have a visible minority, a visible minority Protection Act. Well, those minorities are not just black people. Those minorities are multiples of cultures, even French, even Asian. But anyway, Canada's discrimination practices are so easily visible as their visible minorities, which involves many cultures of people. 16% of the Canadian population known as the protected groups. Those